Hello guys, welcome again to my YouTube channel. We've been away for a while because we were dealing with some technical issues, but we thank God we've been able to resolve. So today we are bringing you news live from the courtroom regarding Mazen Nnamdi Kanu's trial. So today we are driving into a major legal and political drama playing out here in Nigeria, the trial of Nnamdi Kanu, leader of the indigenous people of Biafra, the IPOP. Oh my god, this is so interesting. So what are we expected to see in today's news? So in today's video, I'll walk you through the latest update from the trial, highlight the key developments from today's courtroom session, explore the reaction from legal analysts and the public, and finally answer some commentary and take away on what this could mean going forward. So I would like you to stay put, follow this video to the end as we begin to unravel what's going on presently at the courtroom. Alright, before we jump into the fresh update, so let me take you back to what has been going on. For several years, Nnamdi Kanu has been at the center of a controversial campaign for the indigenous people of Biafra, the IPOB. He has been charged by the federal government of Nigeria over alleged terrorism-related offenses, incitement of violence, and destruction of property. Over time, his case has gone through numerous twists: arrest in 2015, bail, his escape, re-arrest in 2021, and a long legal struggle. Okay, so the court resumed fresh terrorism hearing over the terrorism trial of Nnamdi Kanu before Justice James Omotosho. Here are the key points to note. Kanu has abandoned his earlier plan to call a large list of defense witnesses. He told the court that after reviewing the prosecution file, he believed there is no valid charge against him, and so he says there is no need to present a full defense. 2. The judge instructed him to file a written address outlining his position and to serve as a copy on the prosecution. The judge also cautioned him consult criminal law experts about the implication of his decision. 3. The court has adjourned the matter to 4, 5, and 6 November for the adoption of final written addresses. In essence, the case is nearing a decisive phase. 4. Legal watchers are flogging that Nnamdi Kanu's choice to represent himself and waive a full defense is highly unusual for such serious charges. As one expert says, it is political strategy rather than sound legal wisdom. So in short, the courtroom battle is shifting to written argument, and Kanu is signaling that he believes the case against him is so weak he doesn't need to defend it in the usual way. So why should you pay attention to this video? Please follow me through the end of this video. I believe whatever I'm saying here is really going to interest you, as this is from a very confirmed source. So key issues to note. Number 1, self-representation and waiver of defense. Kanu's decision to forge a defense is bold. Do you understand that Nnamdi Kanu wants to represent himself in court, and that is a bold move that anybody can ever take? And the court allowed him to represent himself, a right guaranteed under Nigerian law. But for terrorism charges, this is virtually without precedent. According to legal analyst Sam Amadi, this is less about legal strategy and more about political messaging. The implication: Kanu may be using the courtroom as a platform to assert his view of being a political prisoner rather than a criminal accused. But legally, defending oneself in such a technical case is extremely risky. 2. Claim of no valid charge. Kanu is arguing that the prosecution failed to establish a proper case, thus he need not respond to it. If the court accepts this, it would undermine the state case in a profound way. But if the court rejects it, the risk for Kanu is that he has essentially put himself in a tighter corner and fewer avenues to come out of it. So political overtone. This is not just a courtroom story for the IPOB movement, for the Southeast region, and for Nigeria federal government. This case carried political weight. How the trial proceeds and the perception around it will feed into narrative about separatism, national identity and the rule of law. Time and next step. With written addresses due early November, the spotlight will shift to how the court assesses the written submission, the strength of the prosecution evidence, and untimely whether the case moves to full defense or a judgment the coming week are crucial. So the next thing we have to consider in this video is, what are people saying? How do people see this case? What are people's reaction regarding the fact that Mazi Nnamdi Kanu wants to defend himself in court, which is really not something that happens in court more often, but this one it's kind of unique to us. So how do people perceive this? What are people saying about it? Number one, legal commentators like Sam Amade had called Kanu's strategy a dangerous gamble, given the complexity of the cases and the caliber of the prosecution. Number two, from the public and media perspective, some see this as Kanu shifting into a political theatre mode rather than pure legal defense for his supporters. The waiver can be read as a strong statement: we won't recognize your process. For detractors, it may be seen as an abandonment of due legal diligence. The government side remains firm that the charges are serious and enough evidence has already been placed before the court. The fact that the cases have been flagged multiple times for trial continuation demonstrates the state's determination. Now, how do IPOB see this one? Among IPOB supporters, this is being portrayed as a victory of sorts, that their leader is standing on principle. But the flip side is that failing to mount a concrete defense could also heighten vulnerabilities. So ordinarily, I believe Kanu move is primarily symbolic. So he's deliberately converting that legal arena into a political arena. Probably he wants to make, he wants to make mockery of the federal government, because he is telling them that they do not accept, he recognize his own charges, that he will not recognize their own charges. Recall that for many years now, Nnamdi Kanu has been held hostage and have not been tried. He has not even been convicted. This is so sad. It is so sad of our constitution. It is going contrary to our constitution. It is going contrary to the rule of law. It is going contrary to our own fundamental human rights. So, however, the legal risk is high. Terrorism trials are notoriously complex. The prosecution has already presented evidence. So, if Kanu gets into a situation where he cannot sufficiently rebut or raise doubt, he may face serious consequences. From the government own side of view, how this plays out will send signal. On the one hand, that the rule of law can handle high-profile separatists like Nnamdi Kanu. On the other hand, that the state may be vulnerable to claim a political witch hunt or unfair trial if process is seen to be compromised. For the region and Nigeria as a whole, the outcome matters. If Kanu is seen to be being treated unfairly, it may inflame separatist sentiment. If he is seen to be held accountable, it may strengthen central authority, but at risk of aligning large number of people. So the big question is, will the court accept Kanu's written submission that there is no valid charge? How will the prosecution respond to this stance? Will Kanu maintain his self-representation and waive defense, or will there be a shift? What will be the political fallout across the southeast and broader Nigeria? And finally, regardless of legal outcome, what message will the verdict send out about Nigeria and how they handle separatist movement and high-stake trial? Please, guys, to continue to follow this page as we continue to give you latest happening on this Nnamdi Kanu's trial. Thank you very much, guys.